Hi, everyone. Harry here to talk about Jack Smith's response to Donald Trump's motion in the Supreme Court for a stay of the D.C. Circuit immunity ruling. Okay, so recall a unanimous, comprehensive, very cogent, bipartisan ruling from the D.C. Circuit includes 6 days, not very long, for him to seek a stay. Otherwise, the mandate, which is the thing that makes the case effective, would just issue. And that would mean it would just go back to Chutkan. So his hand was forced and he had to go to the Supreme Court on Monday, and he did, and he filed a motion for a stay. And then the Supreme Court said to Smith, you've got a week to file a response. Now, recall that Smith, before the D.C. Circuit had ruled, had actually filed a motion for cert before judgment. So it was to move things up and make them fast, but it was saying, court, you need to take this case. It's important. So what would Smith do now that the D.C. Circuit had, in fact, taken the case and decided it? So point number one, a week? Heck, we don't need a week. They file it in a day. So, which does two things. One, first, it's pretty darn swashbuckling and impressive. It's like, the sort of Supreme Court litigation nerds version of let's get it on. I'm ready. Boom, boom. We don't need a week. And then second, or maybe first, it emphasizes, as they do in other places in the brief, we got to go. The speed is of the utmost here, court. And, look, we've done it in a day. Boom, let's go. All right. Now, would they, since they'd already said you should take the case, repeat it? No. They said, don't grant the stay. And their argument is cogent. There was nothing inconsistent about it. They said, look, the D.C. Circuit has now ruled, and we have an opinion out there. And Trump is trying, he's now got the burden of freezing things and asking you to enter a stay. You don't need to. In fact, you shouldn't. To enter a stay, first, it takes 5 votes of the Supreme Court, not 4. So, this is different from the normal question like we had in Colorado. Will the court accept the case or not? Will it grant a stay? I mean, they could theoretically accept the case. 4 people would hear it. But if they don't grant a stay, the mandate, again, it issues. It will go, so they could still be deciding the issue, but Chutkan would be going forward, which is the thing that matters. I don't think it's too likely, by the way, we'll have that breakdown. But point number one, it's all about a stay, and you need 5 votes for a stay, not 4. Even more important, the question of whether you get a stay is very different from the question of the merits of a certain issue. You need a special showing to get a stay, to get the court to, absolutely stop the machinery of justice. And there are 2 points that figured very strongly in Smith's argument, but importantly, under the rubric of don't give him a stay. First, the immunity merits itself, the thing that the D.C. Circuit decided. We know all the arguments against. The D.C. Circuit adopted all the arguments against. Smith has been making the arguments against. But in a stay motion, they're not served up as in, here's the argument. They're served up under the question of, does the person moving for a stay have a likelihood of success? So the overall organizing proposition here is, we got this really solid opinion from the D.C. Circuit. It's correct. Here are the 86 reasons it's correct. And now you see the sorts of things that, on the merits they would be saying, and we've been talking about for months. But it's all under the umbrella of they do not have a likelihood of success, Supreme Court. And everyone's been saying, and I agree, the court is not going to endorse Trump's immunity position, and they're very likely to do something like the D.C. Circuit, and maybe fairly likely to do the exact thing. So, if you're technically a member of the Supreme Court and, whatever you're thinking of, is this important we decide or we're the court? The question before them is, does Trump have a likelihood of success? And I think the fair answer to that is no. And if that's so, you don't get a stay. Then second, there's a question of the balance of equities to get a stay. Again, it's a serious thing to just grind the works of, the motor of justice to a halt. And here is where they're bringing in the speed point. And Smith comes as close as he's come to making the argument that, he is wants to avoid of saying, we got to do this before the election. That's everyone sort of avoided saying those words out loud, but he's come damn close because he said in the past, it's a criminal case. You really need to go quickly. And that's the general rule. But he's come out of the box and said, it involves criminal conduct by a president of the United States, first time ever. And that makes the normal exigency or importance of going quickly all the more applicable. So that's getting pretty close to saying, man, we got to get this decided so the voters have it in front of them, and we got to do it soon. So that's the real sort of thrust of the response. And the thing to keep in mind is we've got a motion for a stay here. So Trump's got to win 5 votes, and Smith has made a strong case. It's just a fact. They've got to, it's got to be votes that he's got a likelihood of success. That seems tenuous to me at best, and also the balance of equities. Okay, what will the Supreme Court do? Kind of whatever it wants to do, it seems to me. This is a big moment. They know it's a big moment. Some among them might think this is for us, we've got to do it. Others might think, oh God, how do we get out of this? And there's an easy enough way. But they will have, the court as a whole, an opinion of whether they think this is their job or this is a job they want or not. They will have that. And the fact that Smith has come in and recommended that they deny the stay, it might be persuasive in some ways, but it's not going to be, have any kind of institutional weight. They're going to decide sort of yes or no. Now, Smith also said, all right, if you take the case, then just please put it on super quick, turn around and do what you've done in the past, and they have. Take Trump's motion for a stay and construe it as also a motion for review, for cert, and we'll respond to the motion for cert. Take this as a response, and now it's served up to you. Maybe there's a reply, but it's served up to boom. Decide, okay, we'll take the case. You don't have to go through a few more weeks of briefing for that. And then do it very quickly, please. Have oral arguments, say, in end of March. Have a decision by end of April. Don't go till June. It's really, really important that we get this figured out, do it fast. So, and there are other things they could do, but I think those are the 2 big ones. Either they'll deny the motion for a stay, and then it's over. Then we're back to, Chutkin's court, and the frolic for immunity is finished, and we have to, recommence where we started. Trump gets to have his, pretrial motions and the like, but I think that translates into a trial, say, in early June. Or they take it, but they do it really quickly. But even then, that's going to give Trump a couple more months and going to put us, up against the heat of the actual election campaign, or so it would appear. And that makes it a lot more complicated. But those are the 2 likely outcomes. We'll see how long they give him Trump for a reply brief, but it might be very short. They have a conference where they get together and decide things on this Friday and then next Friday. Maybe they won't have Trump's reply or everything they need for this Friday, but then they would almost certainly do it next Friday, which is way, way quicker than they do other things, which can, hang around for months before they resolve them. Typically, they tell you the following Monday what they've decided on Friday, but sometimes in a case of real public, importance, they tell you that Friday. So let's say it's probably more likely than not that it's next Friday that they do it. And so we might find out next Friday or the following Monday. But I don't think it goes much longer than that. I think they either will deny the motion for stay in short order, and then we are back on track, or they will in pretty short order take the case, expedited motion for briefing, etc. And so we remain off track for a couple more months. But that's where it's going. So the important thing about Smith, although they'd said take the case before, now they're saying don't take it because it's been decided and he can't meet the standards for getting a stay. And in particular, he can't show he's likely to prevail. That seems a strong argument to me. I'm sure some justices, may think otherwise. We'll see, where Thomas and Alito perhaps are, and is there, dissent from what the court does. But the important thing for us to keep in mind is it's a stay posture, and that really means a heightened showing on his part that 5 justices endorse. And, I think that's a challenge. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.